Stenzel versus Best Buy.
Oopsie. Hi again.
Hi again.
Jill Wheaton from Dykema for the defendant appellant Samsung Electronics. With me is my associate Paul Stewart, and I'd like to reserve 3 minutes for rebuttal. In this case, I'm kind of going to give you this buffet of options. There's 3 things you could find, all of which would require reversal and then re-entry of the judgment in favor of my client. You could find that there's no conflict between these court rules. They can be read together, and when you read them together, a motion is required in order to get, relation back. You could find, well, there's a conflict, but the statute trumps because relation back is a substantive and not a procedural issue. It has to do with statutes of limitations, which this court have held to be substantive. If that's the case, again, statute trumps, statute requires a motion, no motion here, Samsung's out of the case. If you reject me on both those and say, you're wrong, Jill, and you say there's a conflict and the court rule trumps because it's procedural, in this case, the court rule says nothing about getting relation back. And it was only then the court rule that was filed. And because there was no motion filed, you don't get relation back. And because here, you need relation back in order for the claim to be timely, it's improper. So there's lots of ways this court can go. But at the end of the day, the statute says you must file a motion within 91 days of getting a notice of non-party fault. And then it goes on to say, a cause of action added under this subsection is not barred with relation back. And in this case, there was neither that was done. The motion was not filed, therefore the claim was not timely. And the court asked us to address 3 issues, and frankly those kind of are the 3. And the first is there a conflict? And when you find that a statute is conflicted with the court rule and the court rule trumps, you're basically finding a statute to be unconstitutional, invalid, chopping it down. And this court has said time and again that that should only be done with extreme caution. A statute is presumed constitutional unless its unconstitutionality is clearly apparent. And the test is it should never be done when there's serious doubt as to whether there's a conflict. The best proof that there is serious doubt as to whether there is a conflict is the conflict in the answer to that question. The Court of Appeals in Staff in 2000 said, there's a conflict, court rule trumps. The Court of Appeals in 2002 said, there's no conflict. The panel in this case, the special panel, split 5-4, with 5 saying there's a conflict and 4 saying there isn't. So if that's not the best evidence that it's not clear, I don't really know what would be. Anyone have any questions for me? I'm just still rolling along here.
Questions?
Okay, I'll keep going then for a few more minutes, not 16. The court rule does not say that a motion isn't necessary. The court rule instead refers back to the statute, as does the comment in it, which implies that it's including it. And you don't rule something out by not expressly saying, we're ruling this out. The drafters of the court rule, you people or your predecessors back in the day, knew about the statutory requirement. They did not expressly pull it out. If you find, however, that there is a conflict, we would say that the statute still prevails because it deals with substance. And there's a lot of discussion in the briefs about whether or not a statute of limitations has to do with substance or whether this is procedural. And this is one that the Court of Appeals special panel kind of poo-pooed and said, well, it's without question it's procedural. Not that easy. This court made clear in McDougall it isn't that easy. Sometimes statutes can be both procedural and substantive. And when, as here, you're dealing with reviving an otherwise dead claim, that's substantive. Under the Gladich case, statutes of limitations are substantive. But as I said before, even if you find that the court rule trumps, then you can hold that a party can proceed under either. There's two ways to do it. If the court rule trumps, there's no relation back. It's not in the court rule. Or you could say, like the concurring opinion did in the Court of Appeals, there's no conflict. You can read them both, and a plaintiff can proceed under either. Okay. That means if you proceed under the court rule, you don't have to file the motion, but you get only what the court rule gives you, which does not include relation back. If you choose option, curtain B, and you proceed with a motion, then you do get what the statute allows you to get, which is relation back. But the Court of Appeals did this picking and choosing and took its favorite thing from the court rule, which was no motion requirement, and its favorite thing from the statute, which is relation back, and created a new thing and said, basically, you get relation back, you don't have to file a motion, have fun. And there's no statute, there's no case law, there's no precedent for doing that. It's one or it's the other. No questions for me?
Why is that so, though?
Oh, dang it.
I obviously don't think there's a conflict.
I know from your decision in Bint, which I read last night.
Okay.
Ripping.
Strangely, the older I get, the less I can remember, but I specifically remember that case when I was reading this case. So I don't think there's a conflict. Why is it that there's a motion that is required? Why can't you just take the statute and say it shall be granted? So the better practice would be to file a motion.
Yes.
But they didn't. The statute said it shall be granted, and then you get the benefit of the statute. Why is it when you say there's no conflict, a motion must follow and is required, and if there is no motion, you don't get the relation back? I don't see how it all fits together. With the assumption that there is no conflict.
With the assumption that there is no conflict, and you read the two in harmony. The statute says, upon motion of a party within 91 days, it shall be granted. And if it's added under that section, you get the period of limitation. And then the court rule doesn't really talk about much of anything on that, except to essentially claim and make clear to you that the other requirements to amend a complaint aren't required. So the usual no prejudice, the other side, all that isn't thought about. So when you read the two together, it's special rules for when you're doing it because of a notice of non-party fault. Got to be within 91 days, special timeline, and basically you're going to get it because the court's going to grant it. And you get relation back for that. So I think you can read the two together. If you say that, only the court rule exists, which is basically what the Court of Appeals special panel said, the court rule says nothing about relation back. So I don't see why you can take away a procedural requirement for a substantive right. Does that make sense?
To me, the question is,
your question.
Why is the plaintiff not entitled to the substantive right of relationship back where she conformed with the procedural requirements of the court rule, of this court? She complied with the requirements of this court, and then there is a substantive right within our justice system to relationship back. Why do you have to have either the statute or the court rule? Why can't you, in fact, pick and choose and look to the court rule for the procedural issues? Assuming there's a conflict, you look to the statute for the substantive resolution, and that's exactly what the plaintiff has done here, is it not?
No. It is that the plaintiff proceeded under the court rule and not the statute, correct. But I think when the legislature puts a qualifier on a substantive right and says you get this substantive right only if you do X.
But it doesn't say that, of course, does it?
Well, no, of course I'm making it sound a little bit better, but what it says is,
Of course.
upon motion of a party, and then it goes on to say, a cause of action added under this subsection. This subsection requires a motion. So I think it is tied. And to require a motion, it seems, the Court of Appeals said, oh, poo-poo, that's kind of crazy, that's a waste of time. But there is some benefit to this, and the amici kind of talked about this, which is, frankly, well, 2 points. One, to give someone the right of relation back on an otherwise time-barred claim is significant. That is very, very meaningful, very substantive. So to add a relatively minor procedural requirement that to get that you pay your 25 or 50 or whatever it is now dollar motion fee and file a paper is not that burdensome. And to have the motion, there actually is some benefit to that. It's so the court, I mean, Justice Viviano was a trial court judge, so I'm going to say what I think trial court judges do. He can tell me if he thinks I'm wrong. They're not monitoring,
Does
and now he's
Justice
paying
Zara
attention.
get a chance to involve himself
What?
in that answer?
Justice
too?
Zara? Oh, yeah, okay, you too.
You're
Sorry.
probably too young to remember when I was on the trial.
Not that much younger than you anymore, Your Honor, but only since you were in the Court of Appeals, as when I've known you. But anyway, I don't think trial judges pay a whole lot. They're not monitoring every single one of their cases. Where is it at? What's doing? What brings a case to your attention is the filing of a motion. And now something is being asked to be done on that case. And if what's happening is bringing in another party to a lawsuit, a party who otherwise might have statute of limitations issues, a party who's now going to want to start taking a lot of discovery and opening up a lot of cans of worms that might have already been closed. And in this case in particular, it was already a late notice of non-party fault.
Why does the legislature get to tell the court system whether there needs to be a motion or not? Those are all great arguments for why
Yeah.
we might want to change the court rule, we might want to do it differently, because you're right, in Macomb County, I had a busy docket, so unless someone filed a motion or brought something before the court, I'm going to confess, I wasn't reading all 500 files that I had in
I
front of me.
presumed.
So, but why why would we want the legislature to decide which issues could be brought before the court by motion, or by stipulation, or by notice, or by some other format?
Well, it did. Why it can, I don't know. And trust me, there's no legislative history on
did,
it.
but
I
why-
looked.
but-
Right.
but
And I know, I get your question.
That's procedural, right? You acknowledge that. You're saying that we should adhere to the legislature's procedural requirement for a party to obtain the substantive relief that's in the statute. But my question to you is why? And is there any legal authority for that? You said, I think we should have to honor
Yeah.
this procedural prerequisite. Well, that's very nice, but is there any legal
Well,
authority for that?
I mean, look at, for example, what's the case involving court rules? Maybe that's McDougal.
You wanted me to ask questions, by the way, so you got.
I know, I invited it. I didn't want to drive up here for
We
nothing.
get some more questions about yesterday's case, too, and at the end here.
Sure, we'll just go off record on that one.
Right.
I thought today'd be easier, no, whatever. Anyway, McDougal it looked at statutory requirements for the admission of expert testimony in medical malpractice cases. And the argument there was there's a court rule about evidence, and evidence is procedural. So how can the legislature tell us what the evidentiary requirements are going to be? And this court said, well, they can, because those evidentiary requirements go to a substantive right, which is making sure you have a qualified expert testifying in a special kind of case. So they did it there. And if this court frankly felt like you do now, or maybe, which is you can't tell us when a motion is required, then when putting through 2.112K4, you guys could have said, oh, we're going to put in here that motion requirement is not necessary. And you didn't. And so to imply that a statutory requirement, a procedural requirement to obtain a substantive right, and there's a big difference, there's an importance there, to say that that's read out of existence simply because the court rule is silent on it, there's not a whole lot of precedent for that. And it's inherently contradicted for the court rule and this court to then say, and as for the relation back right, because the statute's silent, court ruled silent on that, we're adopting that. So we're rejecting the one part that we're silent about, and we're accepting the other part that we're silent about. That's a lot to ask.
What does it mean upon motion of a party? If a party files a motion, can the party stipulate to the relief, or does the court have to? You were saying there's lots of reasons why there should be a motion. Does the court have to hear the motion? Does there have to be a hearing?
No, I don't think there has to be.
The legislature was getting at when they said upon motion of a party.
I think the legislature was getting at ensuring that the court was aware of this change. A court was aware of what this change was going to be in its docket. This is not something that people will necessarily brief. There doesn't necessarily be a hearing on it. Doesn't need to be a hearing on every motion. In probably 9 times out of 10, or maybe even 99 times out of 100, it's going to be essentially a rubber stamping approval. But the court can make sure that it was filed indeed within 91 days.
It gets pretty far into the weeds on how a court manages its docket, doesn't it? That the court should be, should have a notice of a motion versus notice of a notice?
No, I think, to me, this makes the court, essentially, it's saying, you can't just go off and do this on your own. You can't just be going off and doing something as significant as adding a party against whom claims are otherwise time barred without the court making sure that the timing requirements for doing that have been met. Oh, did this motion come 6 months after the notice of non-party fault? Denied. Did it come within 91 days? Okay, granted. But to have someone there, as opposed to the new party coming in, like we had to do in our case, looking at it, saying, oh, this wasn't done procedurally, hiring counsel, notifying insurers, notifying audit people, all the things a company has to do when they're sued, all that simply because it wasn't done timely. So to have this relatively minor requirement of requiring a motion so the judge can quick look at it, yep, done timely. Oh boy, I was supposed to have mediation on this case next week. We better have a status conference and redo the dates because now there's a new party in here. That's frankly, like I said, not a whole lot to ask when what you're doing is reviving a claim that would otherwise be dead. Anything?
You can
Bueller?
reserve.
Bueller? All right, I'm done. Unless you have more for me. Bye.
Good morning, Chief Justice McCormick, Justice Clement, Justice Viviano, Justice Markman, Justice Zara, and Justice Bernstein. Let me indicate at this time that I'd like to take a point of personal privilege. Seated to my left, Mr. Gary Villas, who's been with me 30 years. Seated in the front row, Miss Lynn Morris, who's been with me 29 years, and Miss Penny Willett, who's been with me 22 years, are deserved a great deal of credit for the embodiment of the work that I've prepared here today and for the last, collectively, 80 years of their wisdom. And so I say that because I think I'd be remiss if I didn't remind this court of how unique an experience it is for a small-town practitioner to appear in the Hall of Justice of the state of Michigan before the Michigan Supreme Court. I've never taken it for granted, and I've never played in a National Hockey League Stanley Cup game or a baseball World Series or even been as a golfer to the Masters in Augusta. But as a professional, as a lawyer, this is as good as it gets. It's an honor to be here. It's one of those unique experiences, and I've had several in appearing before the Supreme Court that I remember throughout my lifetime. It's one of those unique experiences in life of a trial lawyer. After 43 years, it's an opportunity to appear and argue my case on behalf of yet another deserving client that's voice is spoken through me. As I become a senior member of the bar, I'm reminded on a regular basis that I may not have this unique, singular experience again. And so, for today, I appear before you as a lawyer and grateful for my experience to be here. It's an honor being a member of this profession, and it's an honor of the highest magnitude of being before the Supreme Court. I take that with great deference because in this case, I appear before you with almost 10 judges agreeing with me, which is rather unusual for me. I'm usually an appellant where 3 or 4 judges have disagreed with me, and I feel like I have an uphill battle. In this case, I don't disagree with Judge Zara when he was a Court of Appeal judge and authoring the opinion in Bent, where there was a case for a non-party at fault, I think filed 9 years after the complaint was filed. Judge Zara opined that, in fact, in that case, the statute says that the court shall, and that under the court rule, which this body has sole and exclusive jurisdiction of promulgating. Why? Because there's nobody that knows the rules and the recommendations as to how the practice should be handled better than this body. I know that have worked with the state bar, that the state bar voices in on the court rules. And the court rules trump a statute. And the reason is not because the legislature doesn't know what they're doing. The reason is because this body is charged with the sole and exclusive jurisdiction of promulgating the rules on how the courts are going to work. And it makes no sense for a practitioner to be told, notice out a hearing, file a motion, have the other side respond, set a hearing with the court, argue the case, and have the court issue a written opinion when the statute says exactly what Judge Zara opined, when the statute says the court shall allow. And so that's why I presume Judge Zara said there isn't a conflict. It's consistent. It's concurrent. It makes sense. They work together in harmony.
Mr. Nolan, so your view is that the concurrence was correct then? It's not that we should affirm the result and adopt the reasoning of the concurrence?
Well, I think at the conflict panel, the reason the conflict panel was called was because Judge O'Connell said, I don't have a choice. We've got to follow the Williams decision. I don't like it.
I think I might be asking a different question. There are two different ways we can get to the same result. One is, it seems like you like Justice Zara's thinking on this topic that there is no conflict.
I love Justice Zara's thinking, but everybody who says that there's a conflict, I think is not incorrect. In essence, it's almost
well, either there's a conflict or there's not, right? We can't go both ways.
Well,
we're probably going to pick one.
And that's what the majority in the 4-3 decision on the conflict panel said. Whether a party may simply file an amended pleading, there is no conflict on the substantive principle and the intended outcome that the party will.
Okay.
Let me cite that in the brief that we just got handed out, the briefs that the court hands out, on the last sentence, and we hear this enough, it's like you start believing it. It's like the coach on the sideline, Coach Izzo, yelling and yelling, foul, foul, foul. You start to believe that you missed something. There's so many fouls. Here it says on the last three sentences, whether in any event a party may amend a complaint upon receipt of a notice of non-party fault without first filing a motion. That's what the brief is arguing, without filing a motion. The statute says, upon motion of a party. Upon motion, doesn't say upon filing of a motion of a party. MCL 600.2957 parents 2 provides upon motion of a party within 91 days. In 1995, when they went to the legislature, did the disbandment of joint and several, they said apportionment's fault is fair, and that certain parties have time to, after the complaint served on them, serve a notice of non-party fault. You have 91 days after the first response of pleading. In this case before Judge Aquilina, the defendant filed almost 9 months. They gave us a notice of non-party fault 9 months after their first response of pleading. They ask us, will you stipulate, Mr. Nolan, will you stipulate to allow us to file a notice of non-party because it wasn't timely? It's 9 months after the fact, 9 months late. I said, no, we won't stipulate to it. I can't. I'd be committing malpractice. You'll have to file a motion. So they file a motion. So they go before Judge Aquilina. Judge Aquilina says, I'm going to grant the motion. And Judge Aquilina, I will indicate, Mr. Villas argued the motion. She says, I'm going to grant the motion to allow a notice of non-party fault. You'll prepare the order. Mr. Tower answers yes. The court, thank you. Mr. Villas says, astutely, so Your Honor, I have 91 days from the day of the order to amend the complaint. Well, under MCR 2.119, parens A, parens 1, motions during hearing do not need to be in written form pursuant to that court rule. Mr. Villas makes a motion at the hearing. I have 91 days. Her response is, quote, no, what I'm going to do is ask you both to get together to revise the scheduling order because 91 now is not fair, is it, counsel? And she asked Mr. Tower. So the next week, 1 week later, he's got his motion for summary disposition scheduled. It was 2 months out, but 1 week later, he argues a motion for summary disposition, and she dismisses the case. So before the order's entered, we file the motion of non-party at fault to add the party. We file the motion. And not the motion, but we file the amended complaint under the court rule. We do what we're told, we believe, and as a practitioner, we read the court rules. It's not whether we like them or don't like them, but we read them and we know and interpret them, and we filed the amended complaint within days or months of before the orders entered in July, and the rest is history. Now, I know that the first attorneys in the first case got out of control.
They used up 10 of your minutes, Mr. Nolan.
What's that?
I have bad news for you. They used up 10 of your minutes. I'm just kidding.
Yeah, I thought I had a half hour.
You started with 20. You're down to 9:28. You have anything else you want to make sure you say?
Judge O'Connor once said to me, Mr. Nolan, is there anything that you have to say in stepping up to make an argument before the Court of Appeals? And I said, well, yes, Your Honor. He said, have you ever heard of that story about the lawyer that said too much? And I said, yes, Your Honor. He says, what do you have to say? I said, thank you. So, thank you very much, Your Honor.
Thank you very much. I think you reserved a few minutes.
Yeah, I don't have that long bit. Just a couple things. Mr. Nolan talked about the court rule doesn't have to say the other side has to file responses, and I have to notice a hearing, and there has to be an argument. As I pointed out in response to Justice Viviano's question, the statute doesn't say that either. The statute just says upon filing a motion. It does not require a full-blown fol-de-rol that sometimes goes with the motion.
Upon motion of a party.
Right.
Not upon filing a motion.
Okay, I left the actual statute there, but you guys, that's what I mean. And he said they work together. I agree. They work together. They're not in conflict. And when they work together, it means a motion is required. And to read the motion requirement out violates the well-known axiom, principle, with the Latin name, I'm sure, about you should not treat anything, any part of a statute as surplusage or unnecessary. It's there for a reason. We might not know the reason, we might not agree with the reason, but it's there for a reason. And as for the last point, which was that this motion was brought, you can go back and look at the transcript.
Let's go back to that. If the party did file a motion, the court shall grant. Right?
Yep.
Court rule doesn't require the motion. Does that make the statute surplusage? You can still file a motion. You don't have to file a motion, but you can.
Correct. But if you want the relation back, you have to file the motion, because the relation back is only given to you by the statute, and the statute says the exact language, y'all know what it is, but I'll try and find it, so I'm not,
We got it.
thanks,
Yeah.
saying it wrong. But the conversational nature of so I guess I have 91 days is not a motion. It isn't, I'm going to move to amend. It was just, I guess I have 91 days. The trial court was the one who was able to determine if a motion had been made, whether oral, whether formal, and she found that it had not been, and that was the reason she granted summary.
What was the point of us doing the rule? What was the point of us doing the rule if not to have two tracks?
I think the point of doing the rule was to make clear that the general court rule regarding amendment of pleadings, which doesn't say it needs to be done within a certain time period, and which does contain other requirements like not too late, no prejudice to the other side, all of that. This rule makes clear that that general rule doesn't apply. When it comes to notice of non-party fault, you have 91 days, which is not in the general rule about amendment of pleading, and you don't have to prove these other things, like you acted with speed and that the other side won't be. So, and it specifically says, at the top, again, I should have brought it with me, but it basically refers back to the statute. And the courts have said time and again, when looking at 2.112, it was designed to implement the statute. So, yeah, here's how you do it. But a practitioner looking at that can see that in two places you refer back to the statute. So all you have to do is look at the statute. Okay, statute says a motion. And other times you need to amend a pleading. It requires a motion too, except within a certain amount of time. So to require a motion to amend a pleading is not unusual.
Thank you, counsel. The case will
Thank
be
you.
submitted.